Good morning, this is your Kelso Report for Tuesday, March 13th. I'm your host, Clark Kelso. We have cases today arising under the Lanham Act, criminal sentencing issues, and then two cases under civil procedure involving costs and attorney's fees. Let's get started with the Ninth Circuit and a case arising under the Lanham Act, trademark case. Operating since 1986, Skydive, Arizona has become globally famous as a skydiving center, hosting between 145,000 and 160,000 dives per year. As part of their advertising and booking business, SkyRide owned and operated numerous websites describing skydiving opportunities in multiple locations, without reference to specific drop zones. However, SkyRide also owned and operated numerous websites specifically referencing Arizona, many of which referenced particular cities in Arizona, such as Phoenix Skydiving. Well, a number of the website domain names specifically used the word skydive or its variants, including skydiverarizona.net, arizonaskydive.com, and skydivingarizona.com. Skydive Arizona neither advertised with nor accepted certificates from SkyRide. So, as you can imagine, a conflict ultimately arose and Skydive Arizona sued SkyRide under the Lanham Act. The district court entered partial summary judgment on Skydive's claims for false advertising under Section 43A of the Lanham Act. And the jury found against SkyRide on claims for willful false advertising and willful trademark infringement. The defendant argued on appeal that there was insufficient evidence of materiality to establish false advertising, since the plaintiff did not submit any consumer surveys and instead submitted to the court, as part of a motion for summary judgment, only the declaration of a single customer. Well, the Ninth Circuit rejected this argument with its decision in Skydive Arizona versus Quattrochi, where the majority held that a consumer survey is not required as a matter of law in all false advertising cases. And the survey was particularly unnecessary in this case because the advertising which referenced Skydive was actually false on its face. In those circumstances, a declaration indicating an ordinary consumer's confusion can be sufficient. You don't need a consumer survey. The majority also upheld the jury's $3.5 million verdict for actual damages, $2.5 million for disgorgement of profits, and $600,000 in statutory damages for cyber squatting, finding that the jury's verdicts were based on reasonable inferences and fair assessments of the evidence. The majority did reverse the district court's decision to double the actual damages. The district court did this as a way of punishing the defendant. That's what the district court said it was doing. Well, the Ninth Circuit reversed that, holding under well-established law that a district court may not increase damages under the Lanham Act for the purpose of punishing the defendant. It can increase them to make sure there's adequate compensation, but not for punishment. Even with the reversal, it's a $7 million verdict in favor of the plaintiff. Next, a criminal sentencing case. The Ninth Circuit in bank reversed the short sentence given to the defendant, who was convicted on 9 counts of criminal activity associated with his planned terrorism attack on Los Angeles International Airport. The sentencing guidelines recommended 65 years to life for the conviction, but the trial court sentenced the defendant to only 22 years plus 5 years of supervised release. The government appealed on the ground that the sentence was substantively unreasonable. Applying the abuse of discretion standard of review, the majority of the Ninth Circuit in bank held they had a definite and firm conviction that the district court committed a clear error of judgment in sentencing the defendant. Next, we turn to a California Court of Appeal decision involving an award of costs. The plaintiff had filed an action against the hospital and others under the Elder Abuse and Dependent Adult Civil Protection Act, Welfare and Institutions Code Section 15600. The Act contains a one-way attorney fees provision in favor of prevailing plaintiffs only. The defendant made an offer to settle under Section 998 of the Code of Civil Procedure, which the plaintiff rejected. During trial, the plaintiff ultimately dismissed the defendant from the suit, and the Superior Court then awarded the defendant its costs and expert witness fees under Section 998. The plaintiff challenged the award of costs, first arguing that in light of the one-way attorney fees provision, Section 998 should be interpreted as not applying to the plaintiff's claims. Well, in Bates v. Presbyterian Intercommunity Hospital, the Second District rejected this argument based on clear California Supreme Court precedent which distinguishes between attorney's fees and costs. The clear rule is that Section 998 applies unless another statute expressly displaces it. The Elder Protection Act did not expressly displace the Section 998 process. It simply said attorney's fees can be awarded only to a prevailing plaintiff. But that's not enough to preempt Section 998, so the award of costs was proper. The court also held that the defendant's offer was reasonable and made in good faith, and that the Superior Court properly awarded expert fees that had been incurred prior to the 998 offer, and expert fees incurred by an expert who never testified. This is all pretty standard stuff under Section 998. Next, another attorney's fees issue, this time arising under Civil Code Section 3186, which establishes a process by which a subcontractor can submit a stop notice claim to a public entity on a construction project to preserve the subcontractor's ability to get paid. In Tri-State versus Long Beach Community College District, the subcontractor delivered a stop notice to the district stating that $1.1 million of the total contract price of $6.5 million remain unpaid and was due and owing. The Superior Court ultimately dismissed the subcontractor's complaint and then awarded the district attorney fees. The Second District affirmed the dismissal, but it reversed the award of attorney's fees. Section 3186 provides that the public entity shall withhold funds in an amount, quote, to provide for the public entity's reasonable cost of any litigation thereunder. The Second District held that this reference to cost in the statutory language simply meant normal litigation costs, and not attorney's fees. Again, a pretty standard holding. We distinguish between costs and attorney fees. They're different things. And that's it for today's Kelso Report. Have a great day in the law.